I'm Rachel Scott, a personal injury attorney in Seattle, Washington. And if you've been involved in a personal injury case, you might have heard about mandatory arbitration. Today, I'm here to walk you through what mandatory arbitration is and how it works in King County. Now, what is mandatory arbitration? Mandatory arbitration is a process where a neutral third party, known as an arbitrator, typically a lawyer in the community, hears a case and makes a decision. This process is typically faster and less formal than a trial. And in King County, this is used for cases that have a value of $100,000 or less. In fact, in King County, in Superior Court, under $100,000 or less, it is required, and that's why it's called mandatory arbitration. Now, what's the process here? The first step is filing a lawsuit in King County Superior Court, and once the lawsuit is filed, the complaint is filed, you serve it on the defendant files a notice of appearance, and then the defendant files an answer. Once those things have been done, the plaintiff in the case can move to put it into mandatory arbitration. When that's done, you get a strike list of 5 attorneys who are going to be your potential arbitrators. You're allowed to circle 2, strike 2, and then 1 is left neutral. Both sides are given this strike list and have a short amount of time in which to choose and strike the ones that they want. Once that's been done, that gets sent back to King County for them to determine who will be the arbitrator in the case. Once an arbitrator has been selected, you go through dates in your calendar for all of the interested parties, and you choose a date that's usually about 3 or 4 months out for when the arbitration is going to be held. At the arbitration, you hold your case as though it's a trial. You're allowed to present witnesses and your evidence in the case. Now, typically witnesses can be called, but you can also submit declarations in it to make it a much more informal and therefore cheaper process. In my practice, we usually have doctors and chiropractors and massage therapists, physical therapists submit declarations regarding their course of treatment for plaintiff. And once the arbitration has been done, and typically the plaintiff will testify in that matter, then after the hearing, an arbitrator has about 14 days in which to render their decision. Once the decision has been made, they put it in writing and they send it out to all the parties regarding the liability and the damages portion. If you're happy with the arbitrator's decision and neither party objects, that's the end. And if you've been awarded damages, then that check will come to your attorney's office and it will be distributed per agreement. If either side does disagree with the arbitrator, then they can file for a trial de novo in King County. And this just means it gets put back on the trial calendar like you started when you initially filed it, and it will go through to a jury trial just like it would otherwise. There are other steps in the process too, but that's basically what happens. I hope this video has helped you understand the mandatory arbitration process here in King County a little bit better. If you have any questions or need legal assistance, please feel free to contact my office. We're here to help you every step of the way.